Federal conspiracy is one of the most common charges that federal prosecutors file. Federal prosecutors love conspiracy charges for a number of reasons. First of all, they can cast a very wide net. Federal conspiracy allows prosecutors to go after anyone who has an agreement to commit an offense. Anyone involved in a criminal enterprise, whether that agreement was overtly made or implicitly made, falls within the category of people that a federal prosecutor can go after. Second, they can hold people responsible for the acts of other people. So a perfect example is a drug conspiracy charge. Obviously, there's someone at the top that's supplying drugs, the middle level people are supplying drugs to others, and you get this very broad pyramid of people who are involved. You can get someone at the very low end charged with acts of other people who are higher up above them. Perfect example would be someone in that mid-level range has guns that they use to protect their activities or themselves. A person who is arrested anywhere within that conspiracy, even if they've never seen a gun, held a gun, touched a gun, can get charged and enhanced with that weapons enhancement just because someone else in the conspiracy possessed a firearm. And the Fifth Circuit, which is the appeals court that governs our region, has said if it's foreseeable, then that can be used. And within drug trafficking, the position the Fifth Circuit has taken is that guns are a foreseeable part of any drug enterprise. So you can be at the very bottom of the food chain and still get charged with the actions of other people. The third reason prosecutors love conspiracy charges is that co-conspirator statements can be used against you, even if they're hearsay statements. So typically under the law, we don't allow hearsay statements. Those are statements made outside of court that are being used in court for the truth of that statement. So Bobby sold me 10 grams of weed. Typically, that is a hearsay statement that is not admissible in court. But if they say Bobby is my co-conspirator, now that statement can be used against me. So that hearsay statement comes into court. Similarly, in federal cases, once the threshold for the offense has been met, everything else is just considered relevant conduct. So let's put that in context. In a drug case, if within the conspiracy, it's alleged that you moved a detectable amount of a substance, you're typically looking at 0 to 20 years. So you moved a detectable amount, any amount of methamphetamine. So let's say they have 0.01 grams of methamphetamine. That's their starting point. Now what they're going to do is bring in co-conspirator statements or other hearsay statements to say, even without capturing drugs, that you're responsible for ghost dope. So Bobby says, he sold me 10 grams every week for a year. Now you have half a kilo, 520 grams. That's going to be used against you. It's a hearsay statement. It's used as relevant conduct. And because it's relevant conduct, they do not have to prove it beyond a reasonable doubt. Instead, it's a preponderance of evidence. That is just a tipping of the scales. Is Bobby more believable than not? So now you have these massive drug charges that can be built on statements of others. And in fact, in the federal system, there's no requirement for them to capture any actual drugs to build a case against you. As you can see, there are a lot of reasons why federal prosecutors love conspiracy charges. They cast a broad net, they can go after a lot of people, and it essentially lowers the burden of proof that the government has to prove their case by, at least as it pertains to relevant conduct, and that's going to be the major driver of your potential sentence. If you're charged with a federal criminal conspiracy charge, it's important that you talk to an attorney who is experienced in this area, specifically in federal court. Give us a call at 817-203-2220. We'd be happy to walk you through the implications of a federal conspiracy charge.